Just a couple of minutes to get settled in, and once the number stops rising meteorically, we can kind of get started. But in the meantime, welcome everybody. So great to have you. Okay, it looks like the number has paused. So hello everybody. I'm Tejinder Singh from Goldstein and Russell and the SCOTUS blog, and I'm really happy to be here today for our usual annual panel about the Supreme Court. We've done this panel for years now. It's always a ton of fun, and that is mostly because I am joined today by wonderful practitioners who know a ton about what's going on with the court. And in alphabetical order of last name, they are Loren, AliKhan, the Solicitor General of the District of Columbia, Kirti, Datla, Senior Associate at Hogan, Lovells, Pratik, Shah, the co-head of Supreme Court and Appellate Litigation at Akin, Gump, and Kannon, Shanmugam, the head of Appellate and Supreme Court Litigation at Weiss, and the managing partner of their DC office. I'd like, when we come around to everybody, take a second, of course, folks, and reintroduce yourselves. You'll see for the attendees on the list, you'll see our video. We do not see your video. If you would like to ask questions, the Zoom webinar has a Q&A feature that will allow you to type those in. I will see them and I will try to route them appropriately so that we can get to all the questions as we go through. As usual, we have a ton of topics to cover today. It's been a really interesting Supreme Court term. We still have about a dozen cases left to be decided. There's technically 13, but 2 of them are really strongly overlapping with each other. And so, I've treated as about a dozen, and they're some of the biggest cases, but some big cases have already been decided. And so there's a lot to talk about already. But I want to start by talking about what was a little bit different this term. And that was that the term was sort of interrupted by the COVID-19 pandemic. And so obviously this panel, we're doing it remotely, and the court did oral arguments remotely as well. It did them by teleconference only. And the format was quite different from normal oral argument. Instead of having the sort of traditional free-for-all conversation where the justices and the advocates went back and forth, it was a much more ordered conversation where the Chief Justice basically gave each justice 3 minutes to ask questions and get answers, and then cut them off and move to the next one. And every justice asked questions of every advocate, including Justice Thomas, who normally doesn't talk very much. So I wanted to get the reactions of the panel and get a sense for how you think it went. What did we learn about the justices and about the court? What seemed to work well? What were, things that you wonder if they're going to keep or change? Any reactions you have to the remote argument format that the court was following. And maybe let's start, Loren, if you could kick us off and give us your thoughts.
Sure. Well, hi, everyone. I'm Loren AliKhan. Thank you for being here. It's always a fun event at the SAWA convention to chat about the court with these good folks. I think overall it went really well. I liked the way that they ordered it with the chief kind of playing traffic cop and going down the line of justices in order of seniority. It's actually a practice that the DC Circuit adopted a few weeks after the Supreme Court did. So my office had one of the first DC Circuit virtual arguments, and it was a telephonic free-for-all, which was actually quite challenging. And so I think after seeing how successful it was at the Supreme Court, the DC Circuit, I think a few other courts went to that model, which really imposed some order in what is otherwise just total chaos. And I think it really showed us that Justice Thomas does have questions, and very pointed questions at that. And I think he's long been sort of rumored to be frustrated with the sort of pageantry and chaos of the normal oral argument. And so I think by slowing down the pace, by having an order of operations, it really allowed him to get out some very astute questions, and makes me wonder what questions he had in previous cases that he just hadn't been asking.
Yeah, I think that's an interesting observation. Did anyone else on the panel have reactions to Justice Thomas's questions? Did you think they were, I thought that they were interesting because he sort of has a different line of thinking on a lot of legal issues generally. And I think it was revealed a little bit in his questions. I don't know if any stood out to any members of the panel you wanted to share with us. That's a no. All right. No, sorry. I'm going to call on someone because I think people are holding back because they don't want me to. They don't want to talk over each other. So I'm going to call on Pratik. You have any thoughts about the oral argument questioning, either from Justice Thomas or really anyone else?
Yeah, I guess a couple observations. I mean, just on Justice Thomas, obviously that was a great virtue of this, to actually hear what he's thinking in an oral argument. And while he did kind of reveal sometimes his unique thinking, I was more surprised by how often his questions, others teed off his questions, right? It wasn't some idiosyncratic thing. It's something that others played off on. He was obviously up front. They went in order of seniority, so after the chief. So I found that to be interesting. I thought there were virtues, from a public standpoint. We had actual contemporaneous audio and video, or audio feed, right? So that was something that's never happened before in the court. You could hear it live. I guess some people are saying, look, can the court kind of go back to its old thing of not releasing audio until the end of the day or the end of the week? My guess is yes, the court can go back, but some people say maybe they can't put the genie back in the bottle and they'll continue live streaming. So that was what I thought one great thing that came out of it. And I don't think that was a horrendous failure. So hopefully the court will keep that feature at least. And then from an advocate standpoint, to me, kind of the great benefit of this new format was you actually had more of an opportunity to respond to questions more fully. You didn't have other justices jumping in. And so, from an advocate standpoint, that was a great thing. I mean, but on balance, I prefer the old traditional way of doing it. I think the biggest loss from this format is the kind of robust exchange that you get when you do have justices following up on one another. I think both it reveals a little bit more of their thinking when they're kind of chiming in another justice's question or trying to take the argument in a different direction in real time. And it, of course, I think leads to crisper and I think more focused advocacy, because you're really able more readily to pin down an advocate on key issues than I think this format lend itself. So I'm looking forward to the return to the good old days, but I think there were some positive virtues.
Yeah, I think one of the most interesting things about it was because everyone asked questions to everybody. One of the principal predictive tools that we have about who's voting for who was a little bit muted, right? It wasn't totally impossible to figure out where people were coming from, but because you had justices asking questions to both sides, normally justice doesn't ask you any questions, you're probably good with that person, right? Either that or you're lost so badly. But I think that was it was interesting to have that taken away. And I wonder, for people who watch the court really closely, how that changed your perspective on what oral argument revealed or didn't reveal about, maybe how the cases were going to go. Kannon, you have any ideas about that?
Yeah, first of all, let me just say how great it is to be back with everybody, albeit virtually. I think we'd much rather be together in San Francisco. From my perspective, it's a much happier place to be at this time of year than Washington, but it's great to have so many people participating virtually in this panel. I thought that this was something of a mixed bag. On the one hand, I think having the telephonic arguments allowed the court to keep the trains running and to decide some of these cases that were in the pipeline, or at least that the court will have decided those cases by the end of the term, whenever that is. And I agree with Pratik that I think the live streaming was a success. It was interesting. I saw a website that reported on the number of people who had downloaded or streamed the oral arguments, and it wasn't a huge number. I think it was typically in, the tens of thousands. So this was not like, a live Beyonce concert being streamed over the internet by any means. But at the same time, that's many more times the number of people who could get into the Supreme Court courtroom, and a somewhat larger number of people downloaded the arguments afterwards. And I tend to think that we will see at least same-day audio when the court goes back to its more traditional argument format. On the other hand, I do think that this telephonic structure, really didn't lend itself to the robust exchange of ideas that Pratik mentioned. I think when you have 9 justices trying to ask questions, you really do have to impose some sort of structure, as Loren suggested. And the way that the Chief Justice did it was basically to go around the horn, but to impose very rigid time limits on each justice's questioning. And so I think as a result of that, it was very hard to really pin down or follow up with the advocates. And so, as a result, this felt a lot more like a, House through Senate committee hearing than it did a judicial proceeding. And I think it's a lot easier for single judges or even panels of 3 to conduct these telephonic arguments than for a court with that many members. And I'm certainly hopeful, looking ahead to the fall, that the court will find some way to go back to its traditional oral arguments, even if it has to do that without spectators.
Kirti, I think the most important topic for you, and that is the question of the flush. We've had a question come in from one of our attendees, and we can't disappoint our public. So there was famously, a toilet flush during the Supreme Court oral argument. Who did it, Kirti? Tell us. And of course, if you have any other thoughts about the phone arguments, you can give us those too. But mostly I want to know about the flush.
Yeah, fair. I will confess that I have not conducted my own investigation. I will just direct people to what I think is an incredibly thorough, well-researched piece on Slate. And you can listen to snippets of audio and read the timeline and draw your own conclusions. I feel whoever it was, I think deeply upset about it, and I don't know if I want to rub salt in the wounds, but justices are, I think, just as human as anybody else, so that's always nice to know. And I will say, just, this is purely anecdotal, but of those 10,000 people that Kannon mentioned that were streaming the arguments, I got so many more questions from people that either aren't lawyers, like my parents or friends, or people who are lawyers but aren't Supreme Court practitioners. And I think what we, maybe as people who follow the court more closely, lost out on, that kind of rapid fire, keeping 9 perspectives in your head and trying to see what the strategy is. We lost out on that a little bit, but what I think the broader public gained is just, it's much more accessible when people have time to answer questions fully. And then, the next question sometimes, often was directly related to the previous set of questions. So arguments were a little bit more linear. So I know all those folks really appreciated it, at least the ones I talked to. So I think we'll gain something when the court goes back to its normal free-for-all, but they might miss out on it.
Yeah. So the the other thing about the pandemic and the term is that it changed the schedule kind of significantly. There was an interruption oral argument. Some cases were not argued this term; they were kind of kicked over a little bit, and so they're going to be argued a little bit later. So we're not going to have as many decisions this term as we thought, and the cases that we had are being decided a bit later. It's highly likely that opinions are going to be issued into July, which is quite unusual for the court. I guess maybe the fact that they don't have as many vacation plans perhaps is going to be part of the reason they're more willing to carry it over. I think in past years, some of the justices were quite keen to get out of town. I don't know if they'll be doing that. But it's imposed a little bit of a delay to the schedule and changed when some of the cases are going to be argued. But we still do have some pretty big decisions to go over. And I want to start by talking about a recent decision holding that the administration's effort to rescind the DACA program was invalid. And Loren, can you talk us through what happened in this case and the somewhat surprising decision and surprising lineup that we got?
Absolutely. So as I think most folks know, DACA was a program, or is a program, that allows undocumented young adults who came as children to apply for protections from deportation. It also allows them to get certain types of benefits like work authorization or public benefits or driver's licenses. The program has about 800,000 recipients, and President Trump ran on a campaign of ending DACA. And so in 2017, the administration announced that it was terminating the program, which led to lots of litigation. So the District of Columbia, California, and New York, a few other states and cities brought suits, and private corporations, including Microsoft, brought suit. And so that culminated in 3 different cases that ended up at the Supreme Court. So last week, in a 5-4 decision written by the chief, the court held that the decision to end DACA violated the Administrative Procedure Act. The court had an initial question of whether it could even decide the case, or whether it had the ability to review it under the APA, and it dispensed with that pretty quickly and held that it could. And then on the merits, the chief found that the policy or the decision to rescind the policy violated the APA because a key memo from 2017 on which the decision to rescind relied, written by, I think, then acting DHS Secretary Elaine Duke, so didn't focus on the critical issue of DACA, which was preventing deportation, and instead focused on this kind of series of other benefits, about the public benefits, driver's license, et cetera. The court found that by kind of failing to focus on this critical issue about deportation, that this could not be justified under the APA. The government had also tried to rely on a subsequent memo that was written by the DH Secretary Nielsen, and the court dismissed that as sort of a post hoc rationalization of the program. And so really what the court held was that the DACA policy and its validity under the APA sort of rose and fell based on this Duke memo. So the lineup here was interesting. As I mentioned, it was authored by the chief, and then it was joined by the more liberal wing of the court. In addition to the APA holding, the court also considered and rejected the petitioner's claim that the decision to end DACA was unconstitutional because it was motivated by an intent to discriminate. And in doing so, and I think this is reminiscent of the travel ban cases, the majority put to one side comments the president had made both on the campaign trail and after he came into office that could be seen as anti-immigrant. So, as I mentioned, the chief authored it, joined by the liberal wing. Only Justice Sotomayor disagreed with that second point, the discrimination point. She would have allowed the challengers to develop their discrimination claim on remand, but she was alone in that. The chief emphasized that this was a purely procedural decision, and I think in that way it's very evocative of the census case that we saw last term. And so essentially now this is back before DHS to reconsider. I'll talk about the dissents a bit and then kind of what we think is going to happen next. So Justice Thomas dissented, joined by Alito and Gorsuch, and they all agreed that the rescission of the policy was not motivated by an intent to discriminate, but they also found that there was no problem with it under the APA. Justice Alito wrote separately to lament the court's interference with the process. He essentially said that the fact that this has been tied up in litigation since the beginning means that we're now back to the drawing board, essentially at the end of the first term of the administration. And so had the courts never gotten involved in the first place, or had this not been tied up in litigation, this all could have been wrapped up much more quickly. I will note that a theme of the cases that I'm going to discuss today are Justice Alito lamenting things. I think Justice Alito this term was particularly animated, especially in his dissents. And so he, I think, was not shy in writing separately or in leading dissents when he felt like the majority had gotten it wrong. Justice Kavanaugh wrote separately as well, dissenting. He contended that the court should have looked at Secretary Nielsen's reasoning, and the court itself should not have limited, or the court should not have limited its own inquiry to merely the Duke memo. And he essentially said that the consequence of the court's decision is just going to be delay, because this is going to go back to DHS. All of the information and concerns that underlie the Nielsen memo are now going to be part and parcel of this decision of what to do with DACA. And so in that way, he thought this was really just a delay tactic. He also, I think, very pointedly blamed Congress for failing to address this issue. As folks know, Congress has thought about this question quite a lot. They've held hearings, they've had draft legislation, and they've never been able to pass anything. And so I think he, not necessarily teeing off of Justice Alito's concern, but this notion of, are the courts really the right sort of branch of government to be dealing with these questions when Congress could have taken care of this through legislation? I think there's some interesting questions as to what happens now, whether DHS has to start accepting new applications under DACA. Under the stays that had been in place, I think we're continuing to process renewals of applications, but we're not taking new applications. I think that the answer to that question, though we haven't heard any guidance, at least as of today, from DHS, but I think that there's a very good argument that DHS will have to start processing new applications. I think that comes from the fact that the court, the majority at least, endorsed Judge Bates from the DDC's view of the case, and he did not draw a distinction between renewals and new applications. And so I think the stay of his decision is now dissolved, and so I think that the situation is on the ground such that new individuals could be applying. I think were DHS not to process those applications, then we'd end up back in district court, most likely before Judge Bates, with that legal question put very pointedly sort of to him. I guess the next question is, can the Trump administration try and rescind DACA again? And I think the answer is quite clearly yes. Now if they do, they have to address all of the issues that were raised by the chief's opinion. Most importantly, I think they have to squarely deal with this in two parts of the DACA inquiry, the forbearance from deportation on one hand, and then the work authorization and public benefits on the other. And I think they also can't just point to, as they had done prior, the Fifth Circuit decision in the DAPA case and say, well, the Fifth Circuit said it's illegal, so we just have to get rid of it. So I think they're gonna have to really do their homework and issue a more kind of fulsome analysis that might pick up on what Secretary Nielsen had done, or might be something new entirely. I think one other piece before I'll open it up to my fellow panelists is there is ongoing litigation in Texas, where Texas and a few other states brought suit in the Southern District of Texas challenging the legality of DACA. And so the judge there, I believe, had denied a preliminary injunction in that case, but then stayed it pending the Supreme Court's decision in the 3 DACA cases. So my understanding is that a joint status report is due in July. And so, we'll have to stay tuned and see, is this the next DACA suit that we think is going to end up at the court, or is DHS going to do something that perhaps kind of restarts the litigation again?
Mm-hmm. Yeah, so it sounds like, what we're dealing with here is like a situation that's surely going to be evolving in real time. Immigration obviously being a hot button political issue, an election on the horizon, potential change in administrations. There's a lot that seems like could change. But thank you for the comprehensive summary. I think that is super helpful. There was another case that went in kind of the liberal direction, well, a trio of cases actually, and again, sort of surprising fashion maybe. And these were about the scope of Title VII's protections on the basis of sex. Kannon, can you walk us through what happened in these cases?
Yeah, sure. So these cases are flying under the caption of Bostock versus Clayton County. And as Tejinder said, it's really 3 consolidated cases involving the question of whether Title VII protects gay, lesbian, and transgender employees. And 2 of the cases involved gay and lesbian employees, the third a transgender employee, all of whom were subject to adverse employment action on those grounds. And the question was whether they have the ability to sue for employment discrimination under Title VII, which is the federal anti-discrimination statute. The relevant language of Title VII is that it is unlawful for an employer to fire or otherwise take adverse employment action or otherwise discriminate against an individual because of such individual's race, color, religion, sex, or national origin. And the question that was before the Supreme Court, a question that had bedeviled the lower courts, was whether discrimination against an individual for being homosexual or transgender qualifies as discrimination because of sex. And the lower courts had pretty consistently said that it did not qualify until 2 circuits took a different view. And even as this issue came up to the Supreme Court, it was one where the cases didn't necessarily come out on traditional conservative versus liberal lines. One of the leading opinions taking the view that these individuals were not covered was written by Judge Lynch, a somewhat more liberal member of the Second Circuit. And at the oral argument in this case, it certainly seemed as if this case might be up for grabs, and so it proved, with the court ultimately concluding by a 6-3 vote that the statute did in fact affirmatively cover discrimination against an individual for being gay or transgender. The vote was 6-3, and the lineup was the court's 4 more liberal members, joined by the Chief Justice and Justice Gorsuch, and it was Justice Gorsuch who wrote the opinion for the court. This case, I think, in some ways is sort of a classic case of statutory interpretation, because on the one hand, Title VII was enacted, I believe, in 1964, and at the time it was enacted, it seems to be agreed that no one thought that the statute covered discrimination on the basis of sexual orientation, or at least no one was focused at all on that question at the time. And indeed, in the years that followed, there were a number of proposals to add sexual orientation, or more recently, gender identity, to the list of characteristics that are prescribed, which is to say, as to which discrimination is prescribed. But those proposals had consistently not been enacted. On the other hand, the Supreme Court, in a series of decisions, had taken a pretty broad view of what constituted discrimination because of sex, and had said, for instance, that if an employer discriminates against an employee based on sexual stereotyping, based on the view that the employee didn't dress in a ladylike fashion or didn't speak in a sufficiently masculine fashion, that would qualify as sex discrimination. And so the argument that was made by the plaintiffs in this case was, and there were a variety of arguments, but their headline argument was that as a matter of statutory text, discrimination on the basis of one's sexual orientation or status does qualify as discrimination because of sex. And that was the view that Justice Gorsuch, who I think focuses on the text of a statute very much in the vein of the justice whom he replaced, Justice Scalia, expressed in his opinion. He took the view that if you are discriminating based on sexual orientation, that is discrimination at least in part based on sex. And he gave the example of a case where an individual, say a male employee, is fired because he's in a relationship with another man. And he contrasted that to the situation in which a female employee would not be fired for being in a relationship with another man. In his view, it was the sex of the employee, the fact that the discharged employee was a man rather than a woman, that rendered the discrimination based on sex. This provoked one of those dissents that Loren referred to from Justice Alito. I would certainly describe this as, a 9 or 10 on the impassioned scale, because it was quite clear that Justice Alito felt quite strongly about this, and he wrote a dissenting opinion that I think was 50-some pages with even more voluminous appendices. And so if you choose to print out this opinion, either don't print the whole thing or reload your printer before you do. In fact, this opinion was so big that it crashed the Supreme Court's website. And Justice Alito, in that opinion, took a different view of the text of the statute. He sort of pointed out that if you had 4 employees rather than 2, and you had 2 male employees, one of whom was gay, and 2 female employees, one of whom was lesbian, and the gay and lesbian employees were the ones who were fired, it simply illustrated the proposition that a discharge in that case was not due to sex, it was due to sexual orientation. But in any event, the back and forth between the majority and the dissent on that subject went on again at some length. And I think it is fair to say that this is a case that I think is not a straightforward one for justices of a more textual bent, and there were certainly respectable arguments on both sides. To me, the argument that may have tipped the balance in favor of the dissent, but that didn't feature quite as prominently in Justice Alito's dissent, I think probably because it was so long, was the fact that in many other federal statutes, sexual orientation is enumerated separately from sex, which might perhaps suggest that sex is a narrower term of art when it is used in anti-discrimination statutes of this variety. But in any event, it is well worth reading. I would be surprised if we see, a more passionate and frankly combative back and forth in any other decision this term than we had in this decision. And I think that there was a real sense among in the dissent by Justice Alito, which was joined parenthetically only by Justice Thomas because Justice Kavanaugh wrote separately. But I think there was a real sense that Justice Alito thought that this was judicial decision-making that in fact was the equivalent of judicial legislation, and his dissent is very much framed in those terms.
We have a question from the crowd about, in your opinion, under this opinion, would somebody who identifies as bisexual and is fired or not hired for that reason have a claim? So the employer just doesn't hire any bisexual person, whether identifying as male or female, just on that trait. Does the opinion reach that?
I find it hard to imagine that it wouldn't, even though I think that the core of the reasoning would not necessarily apply to those facts. But we'll see. I suspect that case will be litigated sooner or later. Yeah.
Where are my other conservative textualists at? Pratik, what do you think about what's going on here?
Yeah, I mean, to me, one of the most interesting parts about the opinions, aside from the momentous nature of the decision, was its window into textualism, right? I mean, it shows that textualism can be about as indeterminate as the other schools of interpretation or other tools of interpretation that people use, right? You have kind of the leading textualist jurists in the nation kind of strongly disagreeing with one another on the fundamentals of how you apply textualism to a pretty straightforward piece of statutory text. And they come to diametrically opposite results. And so I think for those who think, oh, textualism is there so that we can avoid policy-laden choices and those things, I think this proves that to be false. These are both, as Kannon said, these are both reasonable textualist positions that each side had from jurists who really wrap themselves up in textualism, and yet you have diametrically opposite results. So for me, that was one really interesting feature of this decision. The other interesting thing about this case, I thought, was the Chief Justice's vote. I mean, I'd be interested to know what others thought, but curious to say whether he would have been the fifth vote. For folks who don't follow this stuff as closely, normally when the justices vote in conference, the Chief Justice gets to vote last. And so it may have been that the outcome was already known by the time it got to him. And so is this the Chief Justice really firmly believing in the textualist argument that Justice Gorsuch made? Or is this the chief kind of in his institutional role saying, I don't want a 5-4 decision. Let's kind of save some capital up for the court for some of these other decisions that are going to be coming down this term. This doesn't seem to me to fit the chief's 5-4 profile, like in the census case or in the DACA case that Loren mentioned, because it's not one of those cases where you're actually limiting the power. Like the DACA case, the census case, those are APA cases. Those are kind of ideal vehicles for the chief to kind of send a rebuke to the Trump administration, because it's not really limiting substantive executive authority. You can kind of go back and do it properly and get to the right result, unlike this case. So that's kind of a question I think we'll never know the answer to, but it's one that one that I think about.
And it's one I find really interesting too, because if he were the one in the majority, he would be the one assigning the opinion. And if not, then he wouldn't have the assignment authority. And so I thought that was a really interesting question that a few of us were talking about over lunch. I thought the other really interesting aspect of this case, and I know we have others to go on to, so I'll make it quick, is that the court decided all three cases together. And so in doing that, they didn't draw any distinction between gays and lesbians and transgender individuals. And I was sort of surprised, I guess, about that based on the way the argument went, because there was just so much questioning about the inevitable sort of transgender bathroom issue that the court has been sort of thinking about. And so the fact that it was this one kind of cut and dry, short opinion from Justice Gorsuch that dealt with all of the groups at issue, I was not expecting that.
Yeah. So, all right. So here are the hot takes as I understand them. Pratik thinks textualism is dead, and also the Chief Justice just votes like purely based on politics, doesn't call balls and strikes ever. And Loren, wants genderless bathrooms, which honestly would solve most of the problems in America if we had them.
I disclaim what Tejinder said, with which I usually disclaim whatever Tejinder says, but that one I definitely disclaim. That is not what I'm saying.
So the next case that I want to turn our attention to is one that actually these haven't been resolved yet. But Kirti, there are cases involving subpoenas to various parties that have records that may be relevant to the president. And again, a trio of cases made its way to the Supreme Court. Can you tell us about what's going on with these cases?
Yeah, so there are actually kind of a bunch of subpoenas and a bunch of cases. So one set of 2 cases, which most folks refer to as the Mazars case, involved subpoenas issued by House committees, committees of the US House of Representatives. And they're third-party subpoenas. So they're seeking information from an accounting firm that is affiliated or does work for the president, and 2 banks that are affiliated with the president, but they are not seeking records from the president himself. So one subpoena was issued from the House Oversight Committee, prompted by the president's former lawyer, Michael Cohen's statement that there had been kind of inflation and deflation of assets related to real estate taxes. Another subpoena was issued by the House Financial Service Committee, which was investigating potential money laundering issues with property deals that the president was involved in. And the third was issued by the House Intelligence Committee, which was concerned about whether, any sort of impropriety might have influenced the intelligence activities of the United States. So that's kind of what led to the subpoenas. And then the president's in his personal capacity, his lawyers intervened to quash these subpoenas on the grounds that, they're sort of inappropriate as applied to records that involve the president. And by the time this case made its way up to the court, there were kind of 3 positions that had been staked out by the 2 parties, and then the SG came in as an amicus, offering the court kind of a Goldilocks type situation to pick the one that it likes. So the president's personal lawyers offered kind of the most hard and fast rule. So as the case was argued to the court, the president's lawyers argued that, look, we can tell that these subpoenas were issued by these committees because they sort of have it out for the president and, want to see if he committed a crime. But, actually Congress doesn't enforce the criminal laws of the United States. They legislate, and here there's no real legislative purpose that these subpoenas are tied to, and so they're improper. The SG offered a slightly different position, at least in its briefing, sort of less clear at argument whether its position was that different. But the SG said, look, at the very least, when it comes to the president, you have to have heightened standards in place, and how that cashes out is that it has to be the full House that authorizes the subpoenas, not just one committee acting on its own. The legislative purpose needs to be written down in the subpoena very clearly so we can test it. And all of the information must be, demonstrably critical is the phrase they use, sort of like narrow tailoring for a subpoena. And the House's response to all of this is sort of like, look, these subpoenas were clearly related to activities or to areas that we have the authority to legislate over. So the House Financial Service Committee can regulate banks to address money laundering. The Intelligence Committee can set rules about foreign influence over the intelligence community's activities. And the Oversight Committee gets to enact things like conflict of interest and disclosure laws so that the public kind of knows what public officials are doing. So, this is just sort of standard investigation and furtherance of lawmaking. So we'll just talk a little bit about the other case because they were consolidated for argument, and then we can talk about the argument. So the second case is referred to as Vance, and it arises out of a subpoena issued as part of a grand jury investigation through the Manhattan DA's office, which was seeking the same information. It used the same kind of words as the congressional committees, but it was related to sort of the President Trump and his family's real estate business, and the allegations of hush payments and sort of whether those violated any state laws, state and local laws. So here too, I think the parties staked out sort of very, two extreme positions, and then the SG offered one kind of in the middle. So the president, again, through his personal lawyers, argued for the phrases temporary presidential immunity from investigation and from prosecution. And the theory behind this is that the president is important and has lots of things on his mind. And, if you allowed these kinds of investigations to proliferate, that would distract him from carrying out, important constitutional duties. the SG didn't endorse the words, immunity, but offered sort of a similar test that it had in the other case, which it referred to a heightened standard of need test, which, again, amounted to something like you have to be very specific about why you need the very specific records that you're searching for. And then the Manhattan DA's office relied very heavily on existing precedent. The Nixon case involving the White House, the Oval Office tapes, the Clinton case involving, a deposition of a sitting president, and said that the court has never extended immunity to non-official acts not taken by the president in his official capacity, and that it's permitted very invasive forms of discovery like this before. And, if there's no sort of, this isn't the area for a categorical rule. And if the president thought, in this particular circumstance that this subpoena burdened him, he's always free to come into court and say that, but he hasn't made that case here, and so the subpoenas are valid. So this all culminated in a 3.5-hour virtual argument with multiple rounds of questioning of each of the lawyers. And, I would say this argument seems to me particularly hard to predict because it's one of those cases where the court very clearly was hoping that the lawyers would give it a line. At least a lot of the justices were hoping that the advocates would come into argument and tell the court basically how to write the opinion. And I would say on the side of the House subpoenas, neither side really did that. The president's lawyer sort of stuck to his guns and argued for this kind of, functional immunity in that context too. Anytime there might be a hint of a motive to try and suss out a crime, even if there is a legitimate legislative motive, that dooms the subpoena. The SG's position really coalesced with the president's lawyer's position at argument. It was very hard to see the difference. And the attorney for the US House committees, defended the validity of these subpoenas, but wasn't able to really give the court an answer when asked, for example, why, what kind of subpoena would not be allowed. And so in that way, it didn't really give the court a way to write an opinion, drawing any sort of line between valid and invalid subpoenas. The argument on the New York side of things went a little bit better because it seemed like the default rule was set in a different place by the way the briefing had gone, where I think the Manhattan DA's office did a better job of saying the default rule is that we should get to do this and you have to, the other side needs to give a good reason why we can't. And that seemed to shape that argument much more, and that's kind of an easier position to defend. And so I think the common wisdom coming out of argument was that there might be different results in these two cases, which I think seems right based on how the arguments went and how the advocates were able to put a rule for it. But I will say it seems very odd to me that the New York Manhattan DA's office would have more authority than the US Congress to seek the exact same records. There's something sort of deeply odd about the potential result that might come out of these cases.
Yeah, that's interesting. And, we see here another theme, I guess, which is that I think there's an intuition that if these subpoenas are issued for sort of naked political purposes, that might be improper, but if they're issued for some legitimate legislative purpose, that could be okay. And so you think back to maybe the DACA case, right, where crossing the T's and dotting the I's is really what matters, not substantively, can you do this or can't you? I think everyone would agree. Can you subpoena stuff? Yeah, you can subpoena stuff. It just kind of depends on how. Or with the census case earlier, there's these cases where the why and the how really seem to matter a lot. And then there are cases where it's really more about the what. And so in the DACA case, it was about the constitutionality question turned on, like, well, could you just do this? Or the travel ban case that Loren alluded to earlier. I think it'll be really interesting to see if that's the axis along which these cases are also decided, and if that produces different results in the two cases, because I agree, that would be odd. Was anyone else closely watching these cases and had thoughts about them? Because I thought they were super interesting, including just for the length of the argument. It was a pretty fascinating exercise in back and forth. Okay, well, there's lots to cover, so we'll move along. I want to talk about the Affordable Care Act. There's a couple of cases about the Affordable Care Act up at the court. So there's a case about the contraceptive mandate requirements. And there's also a case just whether we get to have an Affordable Care Act. I think both of those are obviously big deal questions. The second one, obviously subsuming the first. Pratik, can you let us know what's going on with the signature healthcare law in the Supreme Court?
Sure, yeah. Before I do though, Tejinder, let me just point out one thing that I like to do during these panels, which is despite all the changes that happened this term with the pandemic, the one constant was, I think, the outsized presence of South Asian advocates at the Supreme Court podium. There were about 58 arguments, I think exactly 58 arguments this year. 7 of those were done by South Asian advocates. So again, over 10%. And I think Cam and I have been doing this panel since 2010. I think that was our first one in Boston, Kannon. So it's been a decade. And in every year that we've done this panel, over 10% of the advocates have been South Asian at the Supreme Court. I think to me, one of the most exciting things about that is each year there are new first-time South Asian advocates too. In this term, there were 2 who had their first argument, Vivek Suri from the US Solicitor General's office and Mithun Mansinghani from the Oklahoma Solicitor General's office. So joining Tejinder and Loren as kind of the next generation of South Asian Supreme Court advocates. So with that little detour, I'll get back to the programming, which is on the Affordable Care Act now, which is really, maybe I can just say a little bit about that one because that's the only one that's been decided. This is kind of the, maybe one of the lesser known portions of the Affordable Care Act. When it was enacted, Congress set up a risk corridors program, which was essentially designed to entice insurers to join the exchanges to help get the Affordable Care Act off the ground. And so basically how it worked is if you joined the exchange and you insurer lost a lot of money, that is the claims outweighed the premiums because you didn't know what the risk pool would look like, then the government would pay you money for your losses to compensate for some of those losses. But if you insurer made more money than the formula provided for, then you would pay some of your profits to the government. And the idea was, or I think the government's hope was that these would roughly balance out. The collections would offset the shortfall and you would have a rough equivalency. The insurers were not so sure about that. And so HHS made statements in implementing this that said, look, even if we don't think they're going to be shortfalls, but if there are shortfalls, we got you covered. The Affordable Care Act mandates full payment of any shortfalls. So this program was implemented for the first 3 years of the ACA, so 2015 to 2018. It turns out that there was a shortfall to the tune of about $12 billion. And Congress did not make any concurrent appropriation. And so basically what happened is the insurers, when they came to ask for their money, HHS said, sorry, there's no appropriation. Turns out we can't pay that money. So the insurers sued, as any good American would, and they ended up in the Court of Federal Claims, which came out to different results, and the Federal Circuit basically said, no, the government does not have to pay, no appropriation. The Supreme Court, in a rare lopsided decision in the Affordable Care Act context, it was 8-1 with Alito the sole dissent on one of the issues. The health plans, the insurance companies prevailed. And basically there are 3 parts to the decision, which was pretty straightforward. It said, look, the risk corridor statute here is pretty plain. It says the government shall pay. That's the words that it uses for any shortfall. And it didn't have some of the caveats that you sometimes see, like, quote, subject to appropriations. That wasn't part of the statute. So it said, look, this is a mandatory obligation. 2, Congress didn't impliedly repeal that obligation by putting in appropriations rider that limited certain sources of funds. They say got to be much more explicit if you want to repeal an obligation. And 3, that the insurers can sue under the Tucker Act and recover damages from the judgment fund for that shortfall. Basically, the opinion boiled down to one of the last lines, which said, quote, the government should honor its obligations. and 8 justices signed on to that proposition. The other 2 Affordable Care Act cases, I'll start with the contraception mandate because that was argued this term. That's Little Sisters of Poor v. Pennsylvania and the Trump administration v. Pennsylvania. Those were consolidated. Basically involves a question of whether the conscious exemption from the Affordable Care Act's mandate that employer-provided health plans cover birth control, whether that exemption is within the agency's discretion, both procedurally and substantively here. So just to set the table a bit, if you recall, when the Affordable Care Act was enacted, the government initially exempted churches and it provided an opt-out to religious nonprofits from this mandate that employer plans provide for contraceptive coverage to all employees. Then came along the Hobby Lobby decision in 2014, which extended that opt-out of the contraception mandate to private employers, corporations with sincere religious objections. And then came the religious nonprofits who challenged the opt-out. This was first actually came up to the court in 2016 is when this first challenge came up to the narrow exemption that was then in place. And basically the argument from the religious nonprofits then was that, look, this obligating contraceptive coverage and that violates our religious beliefs. So we shouldn't even have to do that. That was the term, if you recall, that Justice Scalia passed away there and basically sent it back and said, look, work it out, lower courts, and hopefully government and religious nonprofits, and hopefully we can avoid this dispute. But now it's back. The Trump administration enacted a broader exemption than the, which everyone now refers to as the conscious exemption. And it basically provides an opt-out for anyone, essentially carves out anyone with a religious or moral objection to the provision of contraception coverage. So a couple states sued, Pennsylvania and New Jersey, who said, look, we'd have to pick up the bill, foot the bill for the employers in our states that opted out under this exemption. Government's now aligned with the religious groups. There's 2 main issues in the case. One is a procedural APA case, notice and comment rulemaking, kind of along the lines of some of the other cases on procedural lines. That wasn't really the focus of oral argument. The focus of oral argument was substantive, whether the agency had authority to create that conscience exemption as broad as it did. Oral argument did not yield a clear answer, at least to my mind. There were a couple of justices who were clear. Justice Sotomayor and Justice Ginsburg made pretty clear in their questioning. This was, by the way, a telephonic oral argument that Justice Ginsburg did from her hospital bed when she was recovering from surgery in May. But Sotomayor and Ginsburg both made clear that they thought the exemption went beyond what was authorized by the statute, which required this sort of coverage. Justices Thomas, Alito, Gorsuch, and Kavanaugh all found that, look, the statute did give discretion to the agency to shape this contraceptive mandate, and so this was within the agency's authority to do it. That left kind of your maybe your new middle ground of justices, the Chief Justice, Justice Kagan, and Justice Breyer, who seemed to be struggling through the course of the argument of trying to find some middle ground. And they seemed expressly frustrated that the parties, the government, the religious nonprofits, and everyone in the courts weren't able to work out a solution that everyone could agree on. So I think it remains to be seen whether they'll actually resolve it this time, or whether it will go back for another round. The last one hasn't been argued yet, and that is, as Tejinder mentioned, whether there should be an Affordable Care Act at all. This is a case that was brought by Texas initially, and it started with a congressional amendment, a very narrow congressional amendment, that basically zeroed out the tax penalty for not complying with the individual mandate. And if you recall, that's how, right, ACA all started. The challenges were about the individual mandate, this requirement or so-called requirement that you purchase insurance. And if you didn't purchase insurance, then you had to pay a tax penalty. So Congress zeroed out when they couldn't agree on repealing in part or in whole the ACA. They agreed on this narrow amendment, which would take the tax penalty to zero. So no penalty if you don't actually buy health insurance. Texas, and joined by other, I guess what people would call red states, sued in the Northern District of Texas. They drew their favorite judge, Judge Reed O'Connor, who is the only active judge in this one division there. They basically argued that, look, the mandate is no longer constitutional because the only justification for it from the first Supreme Court case, which the Chief Justice wrote the majority opinion, was that it's an exercise of the tax power. And once you've eliminated the tax penalty, it can no longer be justified on that ground. Judge Reed O'Connor agreed. But you may ask, who really cares if Congress zeroed out the penalty anyways? What does it matter if Congress struck it, if the court struck it down? It wouldn't really probably matter very much, except for the fact that Judge Reed O'Connor followed that holding with a decision that struck down the entire Affordable Care Act on the ground that it was inseverable from the mandate. That is, Congress would not have enacted any piece of the Affordable Care Act or would have wanted all of it struck down if the individual mandate were to fall. That goes up to the Fifth Circuit, and then some shenanigans begin. You see the Department of Justice, although it hadn't defended the individual mandate, it partially defended inseverability. It then moved to fully align itself with Texas, and you remember that's one of the junctures in which several people left the Department of Justice who had been working on that case. The U.S. House of Representatives thereafter intervened, now Democratic controlled, to join California and the other blue states that were defending the law. And the Fifth Circuit, in a divided decision, affirmed the individual mandate, but said, vacated the inseverability holding and said, basically, there's a do-over on inseverability. District Court, you need to think about this harder and really look at whether the provisions are intertwined or not. California and the House sought cert, court granted. And so now it'll be argued in the fall. Who knows if that'll be before or after the election, which will add some intrigue. Again, the big issues are going to be the constitutionality of the individual mandate, but more importantly, the severability issue, and whether, in fact, invalidation, if the individual mandate is invalid, does that mean other portions or even the entire Affordable Care Act must be invalidated? And we're talking about a 900-page law that touches virtually every component of the health sector, many of the provisions of which have nothing to do with the individual mandate. The one note I'll make is that the Solicitor General just filed its brief yesterday, and the one notable point I'll make for those who watch the court is that Ed Needler, who is the Deputy Solicitor General, the longest tenured member of the Solicitor General's office, who would normally be the Deputy Solicitor General on these sort of cases, did not appear on the cover of the brief. I think that's a pretty telling omission as to the government's position in this case.
So I'm going to poll the panel very quickly. Does anyone think the entire Affordable Care Act is getting struck down?
No.
Crickets. Okay. We are into the lightning round because we've got less than 15 minutes and a few topics left. I do want to at least touch on everything, but we're going to try and go a little quickly. Loren, I'm hoping you can tell me a little bit about what the Supreme Court is doing with guns. There's long been sort of kvetching that the court is not taking enough gun cases. It finally took one, but then that one kind of fizzled. Before you do that, there is a question from the audience that I'm hoping you can answer. Has any South Asian advocate at the Supreme Court been female?
Yes, me. And I do think maybe there was one other person from the ACLU 2 or 3 terms ago, but yes.
Well, actually, yeah, and actually the first ever South Asian to deliver a Supreme Court argument was Preeta Bansal. So yes.
Yeah, I'll just say I said this last year, so I think this is just my hobby horse, but Pratik's comments about representation in the Supreme Court bar are wonderful, but I think the question highlighted that maybe there's some disparity between South Asian women and South Asian men who have the opportunity to argue before the court that we could perhaps do a little bit better on.
I think that is certainly true. There is an overall dearth of women at the court, and I think the last statistic, and I don't know if it's been run for this term, but it was 17% of advocates were women, and that is essentially the same number as it was in the 90s, despite the fact that women are going to law school and clerking and leading firms and leading government offices at a much higher rate. So that is a very interesting question that I think there's a lot more to be done. But on guns in the lightning round, this is another chapter of Justice Alito laments. So New York State Rifle and Pistol Association was the first Second Amendment case the court had taken since McDonald, so essentially the first case in a decade. New York City had a law that forbade individuals who had a home license from taking the firearm to anywhere but a firing range within the city. And so they could take the firearm essentially to one of 7 ranges, but they could not take it to another jurisdiction, to a second home, to a gun show in New Jersey, to Long Island. So the city defended its policy through the courts up until cert was granted. At that point, they saw the writing on the wall and went ahead and amended their law to allow individuals to transport firearms. The state of New York also passed a law, kind of belt and suspenders approach, that essentially put New York City's old law, to bed permanently. So the city then asked that the case be dismissed as moot, and the court really put them through the ringer. There was the court had a full round of merits briefing, there was supplemental briefing on mootness, there was an entire argument in the case. Ultimately, in a per curiam opinion that was 6-3, the court did dismiss the case as moot. They essentially said since the law has changed and they could not go back to the old law, especially in light of this New York state law, there's no longer a case or controversy. So Justice Alito, joined by Justice Gorsuch and joined in part by Justice Thomas, was not happy. He called the city's actions docket manipulation. He said the court should be wary of dismissing a case where the party manufactured mootness. I will side note, outside the Second Amendment context, parties manufacture mootness all of the time by settling cases. But he was really upset by this and thought that it was kind of shenanigans that the city and the state had pulled to try and prevent the court from reaching the merits of this Second Amendment case. He also indicated that there was some additional relief that the plaintiffs could have gotten, and in that he referred to especially money damages, which is curious because to my knowledge, the plaintiffs had never sought money damages, but the U.S. in a brief in support of the petitioners the plaintiffs had said that money damages could be available, which is interesting for a case to get all the way to the Supreme Court and for the first time someone to raise a claim for relief that had not actually been presented in the complaint or briefed throughout the proceedings below. So Justice Kavanaugh concurred in the dismissal. He agreed that the case was moot, but he urged the court to take up one of the then many pending Second Amendment cases, cert petitions that were before the court. So if this is a movie, the narrator would drop in and say, the Supreme Court did not take his advice. So a month later, after the New York case was decided, the Supreme Court denied 10 petitions raising Second Amendment questions, many of which had been held during the pendency of the New York pistol and rifle case. So, court watchers had assumed that the court had this menu of 10 Second Amendment cases before them, and they were going to just try and pick the best one, the best vehicle, the most likely to actually proceed to the merits and not have this sort of New York moot situation happen. I think the denial of that suggests that, well, we know there are 4 votes to take a case because we see that coming from the concurrence and the dissent in the New York case. There's not an appetite to revisit this issue right now. I think folks had long thought that Justice Kennedy was the one who didn't have the stomach for a Second Amendment case. And I think that since his retirement, and especially in light of these cert denials, it really seems to be the chief who is disinterested with taking up the Second Amendment cases at this juncture. And whether that's because he's concerned with the court's short-term legitimacy, or he's trying to go kind of incrementally rather than gangbusters, I think only time will tell. I do think that we are going to continue to see many more Second Amendment petitions, and I think we're going to continue to see Kavanaugh, Thomas, Gorsuch, and now Alito kind of crying out for any individual case to be granted, because Thomas and Gorsuch have long said in dissents from denial that the Second Amendment is getting treated as a second-class right. And Justice Thomas did dissent, this time joined by Justice Kavanaugh, from one of the 10 cases, which was the Rogers case, which involved a New Jersey law that required essentially a good reason in order to get a public carry permit. That good reason requirement has been expressly upheld in the Second, Third, and Fourth Circuits. It's been kind of tacitly upheld in the Ninth Circuit, and it has been squarely rejected in the DC Circuit in a series of cases that I had the misfortune of arguing. So there is definitely a developing circuit split in that area. And so I think that public carry is quite likely the next issue to get to the court. And we do know that there's a real, there's an appetite among the folks that dissented in the New York case. And the question will be, what case can they convince the chief to bring along?
Awesome. Thank you. Thank you so much. Kannon, you have an interesting case going on involving the CFPB. Do you want to tell us about it?
Yeah, and I'll be really lightning given the shortness of time. This is the case on the constitutionality of the CFPB structure. Everyone is probably aware of the CFPB. It's the Consumer Financial Protection Bureau. It was the brainchild of Elizabeth Warren before she became a senator, and it was adopted as part of the Dodd-Frank Act in the wake of the financial crisis. As an executive agency with pretty substantial oversight over the financial services industry. And the director of the CFPB, the head of the agency, is somewhat differently postured from most executive officials. The director of the CFPB cannot be removed by the president except for cause under a standard known as the inefficiency or malfeasance standard that essentially requires the president to have a cause for removal and prevents the president from removing the director at will. And the question before the Supreme Court is whether that limitation, which of course Congress adopted as part of the creation of the CFPB, is consistent with the Constitution, or whether it represents an improper limitation on the executive power. And that issue has been percolating in the lower courts really almost since the CFPB's creation. The court took a case coming out of the Ninth Circuit to decide that issue, and we expect a decision any day now. I represent the challenger to the CFPB's constitutionality, a law firm. It's basically a solo practitioner from California by the name of Salo Law, and the name of the case is Salo Law versus CFPB. I think the interesting questions to watch are first whether the court concludes that this limitation is unconstitutional, and it certainly seems as if there may be a 5-4 majority for that proposition. Second, whether the court avoids that question, and there were a variety of arguments thrown up by the amicus defending the CFPB's constitutionality, since the Trump administration declined to defend that constitutionality, to try to sidetrack the court from reaching that constitutional question. And really third, if the court concludes that the structure is unconstitutional, what does the court do about it? Does it sever the limitation on the president's removal of power, or does it go further and invalidate the entire title of the Dodd-Frank Act that contains the CFPB? So we'll know the answer soon enough. I would expect that we'll get a decision in that case possibly as soon as next Monday.
Yeah, and so that case is one of two cases left from the February sitting that doesn't have an opinion. And the two justices who have not written yet from that sitting are Chief Justice Roberts and Justice Breyer. And, you know, you can sometimes, when you get toward the end of the term, start to draw inferences about how cases are going to be decided. If, you know, there's a case from a there's only one case from a sitting, only one justice who hasn't written it. They probably have it because the justices tried to distribute the work pretty evenly. I want to talk quickly with Kirti about the other case from February, which is the June medical case. And I'm interested to get your thoughts, Kirti, including, you know, which of those two do you think is going to be writing that one?
Yeah, I mean, I think if I had to bet, I'd say Justice Breyer is probably writing this one, and the Chief is probably writing Cannon's case, much as the second part pains me. But I think I can do this one in 60 seconds. If you feel like you have been living Groundhog Day since you have been in lockdown, this case will not ease that at all. Basically, in 2016, the Supreme Court held that a Texas law that required physicians providing abortion services to have admitting privileges and also regulated where those services were provided was unconstitutional because it imposed an undue burden on the right to an abortion. This case concerns a identical law from Louisiana that was enacted in 2014 and has been litigated ever since. And the district court in this case held a trial and made really detailed factual findings that mirror those that were under mirrored the factual findings that underlay the Supreme Court decision in 2016 in Whole Women's Health. The Fifth Circuit departed, usually the standard for factual findings is clear error, and usually that's a really high barrier to meet to overturn factual findings. The Fifth Circuit, to use Pratik's word, maybe some might call it shenanigans, they overturned the district court's factual findings and found a way to distinguish the Supreme Court's decision from 2016, finding, for example, that there were potential benefits to the law and the burden wasn't as high. The case went up to the Supreme Court where the Chief Justice joined with the more liberal justices to stay the effect of the Fifth Circuit's decision while the case was pending before the Supreme Court. I would say argument indicated why appellate judges shouldn't be engaging in fact-finding. It seemed like everybody was quite frustrated with what the record said and what conclusions to draw from it. At some point, Justice Breyer said something like, "We're not going to solve this at argument." So perhaps the reason it has been taking so long is that the justices are spending some real time with the record in this case to see if there really is a basis to distinguish it from the Supreme Court's decision in 2016.
Thank you. Yeah, so I imagine we may be getting an opinion that's all about stare decisis, right, which is a theme that you've seen some of the more liberal justices pressing recently as they get increasingly concerned about precedents they like being overturned. But of course, that's a principle that people only seem to care about sometimes on pretty much all sides. So we were going to talk about the faithless electors cases, but we've already run over time. What I'd like to do is give each of the panelists a minute for any last words about things that they think are important or significant or interesting for what's coming up at the court. Pratik, you were supposed to cover the faithless electors cases for us. Since I'm taking your toy away, I'm gonna kick it to you first.
Sure. So I'll just say a word about the faithless electors, which is let's just all hope that it doesn't matter come this November, whoever you support for president, because essentially that case involves the situation where despite the state's popular vote in favor of the candidate, the elector, which was pledged to that party, votes for a different candidate, which basically the theme of that argument was, we don't really know what the Constitution requires, history is unclear, so let's just avoid chaos. That seems to be the governing principle there. So that's the faithless electors case, which is basically states' attempts to try to keep electors from freelancing on their own and keeping faithful to the state's popular vote. So I think that'll be interesting more as an academic footnote rather than hopefully one that won't have any practical consequences.
Yep. Kannon, I want to know what you've got. And I also, there is a question from the audience directed to you or about you. And it is, could you take Judge Srinivasan in one-on-one basketball? Would you lose on purpose?
I would probably lose on the merits, but if not, I would definitely lose on purpose. I know what side my bread is buttered on. I have to appear before him. In terms of what's coming up, it's going to be interesting to see whether the court subconsciously kind of goes light on its docket for the upcoming year. I mean, not only is there a presidential election in November, but there is such uncertainty about what the landscape is going to look like with the COVID outbreak. And it certainly seems as if the court has almost completely stopped granting new cases for next term. We have a couple of cases on the docket, but one of those was granted before the pandemic hit. And since then, I think the court's granted review in only 7 or 8 cases. And if that trend continues, we may just see another Supreme Court term with a relatively small number of decisions and an even smaller number of really big cases. And I would just add one postscript to what Pratik said a few minutes ago. It's going to be really interesting to see how this Affordable Care Act case unfolds with the intervening election and the prospect of a change of administration at some point while the case is still pending. It's anyone's guess as to how that will play out.
Yeah, I think that is going to be probably the most politically salient case on the docket for next term. And I agree, it looks like, I've seen recently there have been some pretty good looking cases that the court has turned away, things you'd ordinarily think, grant or CBSG and just deny. So it's a good time to be opposing cert, I guess, if that's part of your practice. Kirti, what do you see? What's going on?
Yeah, I just echo what Kannon said, which is it seems like the court is being really cautious, and it's not just an election year in terms of optics. I clerked during the last presidential election, and any election cycle you get tons and tons of stay applications, and it really affects the whole workload of the court. So I wonder if it's uncertainty, if dynamics, the election, the pandemic, I get why they're cautious, but it makes it a little hard to know, what to look forward to next year.
Loren, can you close us out?
Sure. As someone who spends a lot of their time opposing cert, I don't mind this downtick in cases because I feel like it makes my life a little easier. But one case I'd want to draw people's attention to is Texas versus California, which is an original jurisdiction action. So California adopted a policy preventing state-sponsored travel to Texas, and that is because Texas allows foster care and adoption agencies to discriminate against LGBT parents on religious grounds. And so Texas has brought an original action in the Supreme Court over that. And I believe it was just yesterday, the court CVSG, the US Solicitor General's office, so called for the United States to file a brief. There's no kind of hard and fast deadline on when that brief will get filed, but it really shows that there is some interest from the court in considering whether that is a potential case for next term. So I would urge you to look at that.
Awesome. Good tip. Well, thank you so much, everybody. As always, it is a huge pleasure to be here with you. To the members of the audience who sat with us, who asked great questions, thank you. And to everybody, the whole SABA community, have an awesome rest of the virtual conference. And we'll see you hopefully in the flesh next year.
It's nice to see everybody.
Bye,
Thanks
everyone.
all.